Hi, everyone. I'm Maggie McGrath, senior editor at Forbes. According to the Associated Press and the Whistleblowers Association, an internal memo circulated among the ICE agency allowing ICE agents to enter people's homes without a judicial warrant. Joining us now is a lawyer who can talk to us about the legality of such a memo. She is Kate Lincoln-Goldfinch, an attorney, CEO, and founder of Lincoln-Goldfinch Law. Kate, thank you so much for being here.
Thanks for having me on.
So, as I noted, the Associated Press is reporting on this leaked internal memo where basically it seems to allow that immigration and customs enforcement agents can enter someone's home without a judicial warrant. Is this legal?
No, it is not legal. It's very clearly not legal. Administrative warrants are not judicial warrants. They don't go through the legal process that is required under the Fourth Amendment of the Constitution. There's a very clear prescribed process to protect people's rights in which a judge, usually a magistrate, will review evidence and decide whether a warrant to enter someone's home will be issued. And it's not until going through that process that law enforcement gets the permission or the approval to break into somebody's home or business. An administrative warrant is just paperwork, essentially, within ICE. It's an internal DHS or ICE piece of paper that says this person is on our list. And lots of people get placed on the list for lots of different reasons. And it is really concerning that ICE is behaving as if their administrative warrants give them permission to break into people's homes, and it is not legal.
So, just to maybe zoom out and clarify for folks watching, in a normal constitutionally legal scenario, if a federal agent is approaching their home with a warrant, 9 times out of 10, 10 times out of 10, that is a judicial warrant. It's not an administrative warrant, as you were just describing.
Well, historically, a judicial warrant is what we would see law enforcement come with to somebody's home. What's happened in the last year is that the Trump administration uploaded almost 1 million administrative warrants into the national database. It's called NCIC, and this is the criminal database that all criminal agencies use when they run somebody through their system. So unfortunately, many of these administrative warrants were created and then were shared with law enforcement. So that has created a fair bit of confusion and shifting policies amongst various law enforcement agencies. If you think about each state and locality probably has a local police department, a state trooper, a county sheriff, and each of these agencies now has to grapple with what is an administrative warrant? What does it look like? What information supports it? What do we do with these? Do we contact ICE? And so it's created a lot of instances, not only where ICE itself is creating its own warrants based on whatever evidence it wants and then going out and going into people's homes, but it's also sharing all of this information with other law enforcement agencies, most of whom weren't prepared and haven't known what to do with it.
Now, the memo says in part, and I'm quoting here from what the Associated Press was reporting, although the U.S. Department of Homeland Security has not historically relied on administrative warrants alone to arrest aliens subject to final orders of removal in their place of residence, the DHS Office of the General Counsel has recently determined that the U.S. Constitution, the Immigration and Nationality Act, and the immigration regulations do not prohibit relying on administrative warrants for this purpose. End quote. So there's some legalese in here, but let's kind of zoom out for a second. The Constitution, immigration law, nationality law, those three entities were cited in that quote that I just read. How does that justification strike you as a lawyer when you hear that argument?
It's very flimsy justification. First of all, the Constitution says otherwise, and there is a very robust and lengthy body of case law in the United States from the Supreme Court, which talks specifically about people's rights. I mean, when people's liberty is at stake in the criminal justice system, there's just a lot of rules and protections and due process and case law about this. So for one memo to just all of a sudden claim that the Fourth Amendment doesn't apply, it says other than what it says, and we're changing the way that the law has been applied within the court system with a secret memo just doesn't fly, and it won't in court when this ultimately gets to court. But this is behavior that we've seen from this administration where they want the law to be different, they want the application of the law to be different, or even facts to be different, and so they'll just state it both in executive actions and in memos and in press conferences. And it's incumbent upon all of us, is residents of this country, to pause for a moment and understand that just because they say something in a memo doesn't make it true.